Hello, my name is Professor Shiladitya Rakshit. Corporal punishment. Introduction. Corporal punishment is any punishment that involves any form of physical force and is further intended to cause any form of pain or difficulty to the child of any degree. The major forms of corporal punishments that are inflicted upon children are related to slapping, spanking, or using any object in order to cause pain on the child. Apart from the physical forms, there are several non-physical forms of punishment that can be something like mental torture. These forms of punishments might include humiliating or threatening or using abusive language with the child. In India, corporal punishment is pretty common. Every 2 out of 3 schools in India still face physically abusing the child. It is generally the boys who are more prone towards abuse, and this form of punishment takes place not only in government but also private schools. Generally, this kind of behavior by the authorities of the school is used and described by them to discipline the children. India seems to protect children from subject to punishment in schools, and the laws are laid down under the Indian Penal Code (IPC). However, there are several loopholes that are there in the laws even in such brutal crimes and punishments that are inflicted upon the children. Section 83 of the IPC lays down that any act that is done by a child from the age of 7 to 12 and is of immature understanding would not have said to have committed any offence. A child who has not attained the age of maturity in understanding to judge what the nature and the consequences of his conduct is on that occasion. In this understanding of Section 83 of the IPC, it can clearly be said that any child between the said age cannot, if does not do his homework or follows the dress code at school, should not be punished, or there is no scope of corporal punishment. Thus, it is clear that India actually has provisions against corporal punishment, not only under the IPC but several other acts. Even though these are present, it is true, on contrary, that there are several cases of corporal punishment that are reported and there are several unreported ones, which means that the children remain silent. Corporal punishment is not only a crime in India, it is an illegal practice in several other countries, and there are several international laws that also deal with corporal punishments. Learning outcomes. After completing this module, students should know and understand types of corporal punishments inflicted on children, laws in India that prohibit or against corporal punishment, and several reported cases of corporal punishment. International laws dealing with corporal laws and comparison of Indian laws and other countries' laws on corporal punishment. Types of corporal punishments inflicted on children. There are many ways in which corporal punishments can be inflicted on children. The type of corporal punishment that are inflicted upon the children depends upon the culture of the school. Several times, the type of corporal punishment that is inflicted on the children also varies in the urban and rural areas. The reasons of the punishment are generally the same. Most common types of corporal punishment are as follows. Caning. One of the most forms of punishment is to cane students with a wooden cane. Schools authorities inflicting such punishment is actually a very humiliating experience for the child, especially when it is done in front of other children. Caning can leave marks on the body of the child and may cause blisters to form and redness in the skin. It is always advisable for the parents, if they come across such an injury on their child, that there should be immediate action. Slapping. Slapping a child by the school authority with their arms is another form of punishment inflicted on children, which is another form of humiliation for the child. Hitting with object. Many a time, teachers use wooden or plastic scales or throw dusters or pens on the children. This is another form of physical abuse or injury that is inflicted upon the children. There are many such objects that are used, they hurt the child and also cause embarrassment in front of the class. Verbal abuse. This is another form of common punishment, though this is not a physical form of punishment, yet it does cause psychological disorders. This form of abuse in front of the entire class is nothing but completely harsh behavior on the children by the teachers and the other authorities. Corporal punishment at home. Domestic corporal punishment is the one that is inflicted upon the children by their parents. In certain countries, corporal punishment is said to be legal but restricted. In the United States and most Africa and Asian nations, corporal punishment that are given by parents are said to be legal also, inflicting injuries or punishing the children with certain objects like belts are legal as well. In countries like Canada, spanking by parents to children are legal. It is only allowed on children above the age of 2 years and below the age of 12 years. Though this is allowed, it can only be done by parents with bare hands, and no use of things can be done like belts, paddles, etc. These are prohibited. In the UK, spanking or smacking is said to be legal, but the degree of spanking and smacking is a restriction, which means that if a child is smacked upon, there should be no marks that can be left on the body of the child. Corporal punishment in school. Inflicting injuries or corporal punishment in schools on children because of their misbehavior or in order to discipline them is very common and is observed in many countries. These include to spank the child or use things like a cane or a scale or a spanking paddle, which are in many schools in different countries are kept for the similar purpose. There may be certain restrictions in some jurisdictions. Like for instance in Singapore, caning is allowed only on the boys. In India there is no such law, but usually the boys were inflicted injuries upon. Laws in India that prohibit or are against corporal punishment, constitutional provisions and their interpretations. Article 21. This article of the Constitution provides the right to live with dignity. The article has also been interpreted to provide free and compulsory education for children up to the age of 14 years. Corporal punishments leads to the physical abuse which inflicts the fear in the minds of the children, and then these children tend to avoid school and also drop out completely. Article 39E. Under the article, it is clearly mentioned that the health, strength of workers, women, men and children of tender age are not abused. This is to be implemented by the state, and the state is the one which needs to work progressively towards this. Article 39F. This article works towards emphasizing on the state that they make proper arrangements and that they provide and give children opportunities and facilities in order to develop a healthy living. The Indian Penal Code, as mentioned above, the Central Act, that is IPC, does protect children from the age of 7 to 12 for any wrong they do. They cannot invite corporal punishment for themselves. This is, in a sense, also means that children of this age, if they do not do their homeworks or they fail to dress in their appropriate uniforms, there is no right that is given to the school authorities to hit or physically punish the children. The principle that lays down this law is doli in capaxi, which prevents children of the age of 7 and below from any form of punishment. In reality, corporal punishment is not really covered under any provisions of the Indian law, and there is nothing that punishes the perpetrators of this physical harm. The above mentioned provision of law do not actually make a distinction between the adult and the child. Corporal punishment in schools and other institutions are considered to be widely accepted as a social norm. Provisions under the IPC can be used as laws for corporal punishment, but they are rarely used. The RTE Act of 2009. This act, which had come into force on the 1st of April 2010, clearly prohibits any form of physical harassment or mental harassment. Under section 17(1) of the Act further makes it a punishable offence under section 17 clause 2. These provisions read as follows. 17. Prohibition of physical punishment and mental harassment to child. Clause 1. No child shall be subjected to physical punishment or mental harassment. Clause 2. Whoever contravenes the provisions of subsection 1 shall be liable to disciplinary action under the service rules applicable to such persons. Further, sections 8 and 9 of the Act authorizes and places a duty on the respected state governments and the local authority to make sure that no child from the weaker or the disadvantaged section of the society are not excluded from completing their education. The Juvenile Justice Act of 2000. This is an important act that actually criminalizes all those acts that may cause any child mental or physical torture. Section 23 of this act covers all the actions by any persons who has a charge or guidance over a child. Though this section inclined more towards institutions that are regulated by the Act, but nevertheless it does apply to cruelty by any authority at any position over a child, who includes teachers, parents or guardians. Criminal liability in India for corporal punishment requires a malice on the part or from the teacher's end. In many situations, negligence and unreasonableness can also replace malice and can create a ground for injuring a student or causing simple injury under the Indian Penal Code. In one of the cases called Ganesh Chandra Shah versus Jinraj Somani, another case State versus H.A. Khandkar, it had been decided that if the teacher who had caned the student had inflicted blows on the face, thus causing bodily injury and loss of tooth, was held to be criminally liable, even though the defense of the teacher being that he was acting in good faith and for the benefit of the child. It is said that if the teacher exceeds their authority and they inflict bodily injuries, then they would be liable under section 88 of IPC, and the defense of good faith would also not be allowed. Reported cases of corporal punishment. Kolkata's very famous school student Rowan Raula of La Martiniere for Boys School, 12 years old, had committed suicide after he had been caned at school. He had been caned repeatedly by the school's principal. After 4 days of the incident, he found him hanging in his room. The investigation was on relating to the fact if the caning of the principal had led to the child to kill himself, but as per the maximum doubt, it had been said that it was the principal who had caned the student, for which he had taken such serious steps. international laws on corporal punishment. With the evolution of laws over time, there have been a number of treaties and documents that have discussed and talked about the rights of a child. Before the Second World War, the League of Nations had adopted the Geneva Declaration of the Rights of the Child in 1924. Further, the United Nations in 1946 had taken its first building steps in declaring the importance of child rights by establishing the United Nations International Children's Emergency Fund. After this, the UN General Assembly had adopted the Universal Declaration of Human Rights, which was the first document that recognized the importance of the need to protect the children. This document was focused on the rights of the children, and it was more of a moral guide than a legally binding document on the government. The United Nations Conventions on the Child Rights has now been signed by 192 countries. 2 countries which have not signed the same are Somalia and the United States. India had signed and had ratified with the document in the year 1992. Somalia did not sign the treaty because they do not have a stable government, whereas the United States has signed the document but not yet ratified it, showing the intention to ratify it. The convention has certain articles which are related to and can be linked to or laws that can be for corporal punishment. Article 19 says that states shall take all steps of necessary actions that would be important to protect a child from abuse, exploitation or neglect. The state has to make mediums ensure that the child is being prevented and has sufficient protection and rehabilitation. Article 32 further says that every child has the right to be protected from any form of economic exploitation or from any work that would bring about adverse effect on the health of the child, either physically or mentally or in their development, and children should be protected from any work that is considered to be hazardous and dangerous in nature. The state must establish the minimum age requirement for working in certain sectors of industries along with employment hours with regard to children. Article 37 provides that the state has to ensure that no child is facing any form of torture or any other inhuman treatment. These are certain provisions that are related directly to corporal punishment and towards ensuring that children are not subjected to any form of physical or mental abuse and torture. Laws that exist on corporal punishment in other countries. Laws in Sri Lanka, Bangladesh and Nepal. Sri Lanka. The Penal Code of Sri Lanka does not have the reasonable chastisement as a defense for the prosecution if they cause physical harm to a child of any nature and type, and it is not criminalized by the court. It does provide that if corporal punishment is reasonably being used, then it cannot be considered within the scope of an offence. This shows that in Sri Lanka, a parent has the right to inflict simple injuries on a child. Corporal punishment is used in Sri Lanka to discipline within family and mainly is used on boys in school. Nepal. The Nepal's Children's Act, Article 7 says that no child shall be subject to torture and cruel treatment. Further, it justifies by saying that scolding a minor, beating a child by his father, mother or any member of the family, or even for a fact a guardian and a school teacher, is allowed for the development and interest of the child and shall not be considered to be illegal or will not violate the Act. Bangladesh. The Juvenile Justice Act of India and the Bangladesh Children's Act have included an offence the offence of cruelty on children, which involves offenders like parents, guardians and teachers as well. Bangladesh's Act does not count whipping a male child as an offence in their laws. Laws in United States. In a landmark judgment of Goss versus Lopez, the Supreme Court of the United States of America had come to a decision that the constitutional protection of cruelty and degrading treatment did not apply to school discipline and that parents could only bring a civil action and could only claim for relief. In another case of Ingraham versus Wright, it had been decided that corporal punishment was not violative of the Eighth Amendment ban on the cruel and degrading treatment on the grounds that constitutional protection was not necessary. Schools were open institutions where children were at their own will and could leave. In the US, almost half the states do legitimize corporal punishment, and even where they legitimize only minimum or reasonable corporal punishment is protected. Most of the northern states have laws that are completely against corporal punishment. States like California, Michigan, Lava and a few more. Conclusion. Alternatives to corporal punishment. Maximum of the corporal punishment result in some form of injury and also have massive psychological effects. Corporal punishment inflicted in schools is embarrassing and shameful for the students, and it may also be counted in the forms of mental torture. There are few alternatives that can be used instead of corporal punishment. These alternatives have been useful and proved to be successful in few countries. Detention and courts are two of the most common forms of alternatives for corporal punishment. Detentions can be used in order to make the child spend more time with the teacher in forms of providing tuition or doing homeworks, and in this work the teacher can also help the student to develop in the area where he has been punished for counseling. The another form of verbal remedy, but a positive one, or maybe mentoring or isolation or withdrawing privileges from the student, can also be used instead of corporal punishments. It is necessary for corporal punishment in the form of injuries to be removed, and that if not these, then some other form of remedy is found and used. It is because if children are hit in front of other students, they become mentally disturbed, and there can be several consequences of this, like suicide or revenge or harmful or disrespecting behavior. That one punishment is not really good for the future of the child. Thank you.